Greetings all. Just a quick note before we get into this interview. We had tons of technical difficulties. I had to try from 3 different locations. I'm not sure if it was
Hey, flying off back there. Go get him.
Just a quick note to everybody. I'm at Alphonse's house. I just got here. I haven't had time to be. That's his puppy dogs, of course, and I didn't have any travel time to get all this put together. But what you're about to hear is an audio recording between Mark Weber, which is the disciplinary chairman for the Nebraska Supreme Court. Charter West Bank accused Justin of practicing law without a license, and the next audio recording is their conversation about the allegations. And then we go into the interview with Justin, and it's a little bit disjointed because I had to try it from 3 different locations because we've had so much connections issue and whatnot. So the beginning of the interview is a little disjointed, so just bear with us. But we covered all the ground. Just wanted to make that quick note before we get into the video so y'all understand what's going on. And I haven't had time to properly put it all together, but I wanted to get it out, and here it goes without further ado.
Thank you for calling Council for Discipline. Press 1 for Mark.
If I were to
2
guess,
for Kent, 3 for Jared,
I'll hit
4
1
for
and
Elena.
it will ring this time, all the way through to voice. Mail. Instead of 1 ring.
Mark Weber.
Mark?
Yes.
Hey, this is Justin Riddle.
Oh, hey, Justin. Sorry I missed you yesterday. We're in our bar annual meeting, and I'm in meetings all week, but got today or this morning off at least.
Sure. Do you have time to meet, or do you have time to talk?
I have time to talk, yeah.
Sure. So, you sent me a letter, and it says that you received a complaint in July. You don't show me who this complaint is for, what it's from. Where would I find that complaint?
I have it now. We don't actually always make those public.
Well, I'm not the public. I'm
this
the
is a
accused.
complaint.
That's a huge difference. So.
Yeah, you are. Yeah, well, I got you. Yeah, it's something with your charterwest.com, avoiding lawyers and offering legal advice.
Yeah, I'd be curious to see the complaint.
Yeah.
I mean, I'm being accused of something, and you guys are asking me to sign something, but you didn't show me what the accusation was. That's just basic due process.
You a summary of it.
No, I want to see it.
Yeah. Well, I'm not so sure we're going to release that.
Well, and I'm not so sure that you even have something that exists, because if you received a complaint, but you can't specifically... Okay, summarize it for me.
Well, I'm driving right now. I tell you what, why don't you send me an email?
No.
And
No.
Oh, okay.
You said you could talk. You just said you could talk. I asked. Okay, you can't summarize it perfectly, but what can you tell me about it? What did it say that led you guys to conclude...
Well, the charterwest.com that you're using as your, quote, business name is...
I don't use it as a business name.
Well, you use it as an email address or website, and...
I own the website, yes.
And you're... Okay, that's fine, I know that. You're offering advice on civil litigation and appeals.
Such as? What kind of advice? General advice or specific case-specific advice?
Well, I guess you got me in a bad mood. I'm not in the mood to be cross-examined. I'm presenting you with What we have is allegations that you're maybe practicing law without a license. I don't know if you're doing it for profit.
No, you.
That's not necessarily required.
So what you're saying is that somebody said that they think my website is too technical of general information, because Wikipedia also presents information like that. What is courtroom etiquette? There's a million websites that aren't legal that say, what is courtroom etiquette? That's the kind of information.
We received a complaint about you. And that's
but what was the complaint? See, you haven't answered me, and this is what I don't understand. You've had it for 3 months, according to your notes. So in 3 months and an investigation, you can't even tell me what the actual complaint was about. Just that generally they thought I might be practicing law because of the website. So how did you make the conclusion that I was? Who was in charge of the investigation?
I don't have the complaint in front of me. The UPL Commission reviews complaints upon receipt and directs me to make further inquiry, which is why I sent you a letter.
But you said you've already made your conclusion.
The UPL Commission asked me to inquire and get your position.
So it says
on whether or not you're offering legal advice and practicing law without a license.
The commission reviewed the complaint and attached documents. Based upon its initial review of the facts provided by the commission, it appears you are offering legal services to Nebraskans without proper licensure. So that's a conclusion. That's what it appears to you.
Yep.
So what?
That's what it appears to the commission. I'm the messenger.
Okay, but so who do I need to talk to? Because if we're going to play this same game that I always play, which is, sir.
Always. So you've done this more than once.
Not with you folks, but I've done it with the Attorney General. I've done it with the Ombudsman's office. I've done it with Omaha Public Schools. Did they set you up? You literally don't know anything about me, do you? They set you up. Who set you up?
I know.
You got set up because I guarantee it wasn't some random complaint. You got set up. Probably by the same person who got set up by Baird Holm last week. I'm telling you, you got set up because you know what I'm going to do now? I spent some time last night. I'm just going to give you my playbook because you deserve it. First Amendment violation, freedom of speech. By trying to muzzle my sharing of knowledge, if I was, which I'm not, which is why I know you guys have zero evidence or documents of anyone. It says you have documents proving, let's see, it says, where's that? Referral, let's see. I know it says authorized practice. The commission started.
Well, you don't have to read it to me. I know. I authored the letter. So
sure.
Why don't you respond?
I'm not. Let me explain something to you.
And you say you have First Amendment rights. Everybody knows that. But if you deny the allegations, then tell us.
Hold on. Them. You missed the point. They set you up, and it's gonna make. Look, I've always wanted to go argue in front of SCOTUS. I did argue in front of Nebraska Supreme Court, and I won unanimously. Now I have a reason, because I'm going to eviscerate the unauthorized practice of law. It's unconstitutional. It violates the First Amendment in several ways, the 14th, the 6th, the 9th. It's an ethical violation. It's a substantive due process violation. There's multiple ethical violations. It's a conflict of interest. 13th Amendment. Hold on. What would be nice would be to know how you guys came to, you're asking me, and I've already told you that you have no evidence.
All right.
There's no real complaint. I've never practiced law. I don't charge anything for advice. Nobody asks me for advice. Everybody I know thinks they're annoyed that I talk so much about the law that I'm involved with my cases. So I know you guys are lying. Why are you lying is the question. You can't even explain to me how you came to your conclusion.
I didn't come to the conclusion, the commission did.
And how do I speak with them?
Like I said,
Because if we've just got this arbitrary commission that is going to hide in the background like everybody.
Hide the allegations and state your position. And
hold on. You sent me a letter saying you want me to sign something off.
This is not productive. Well, then refuse to sign it.
I'm not stupid. But my point is, this right here is retaliation. It's harassment.
Retaliation.
Absolutely, it's retaliation. It came the same day as the motion to dismiss from that case from last week, after she got set up and realized she couldn't dismiss it with prejudice because I was correct. So the very next day, all of a sudden, you guys, what took?
Talking about.
Right.
I don't know what you're talking about.
So okay, let's do this. Legally,
unproductive.
I'm going to
Send something in
sue.
writing.
I'm going to
Give
sue
me
you
your
guys for
position.
this if you do not provide me even at least a redacted something that shows the date and my name in the complaint, because I know it doesn't exist and I want to go to discovery, because when I prove that'll make it even easier. Either you're going to provide it to me or I'm going to compel it. And nobody wants me to do it that, everybody's going to hide and lie just like they have. The Attorney General, they put lies in writing. When I tried to get them to fix it, you know what they did? They trespassed me from the office and my mother. You're all a bunch of liars. And I am going to make sure the world knows
I
it.
don't know what you're talking about.
Then how did you,
Okay.
then hold on, then why are you so evasive? If you don't know who I am, why aren't you answering the question simply?
Well, obviously I know who you are. I sent you a letter and you responded.
Yeah, but your whole investigation, by the time you sent that letter, you should be able to say to me, sir, somebody said this specifically. We looked, we determined it was true. What you're saying as well, something about a website that maybe gives some legal advice, and, you've got a YouTube and you tell people how to do things. And, well, you know what? I'm allowed to say what I want. Anybody can say what they want. It's not a threat. It's not illegal. I'm not telling anybody specifically, hey, do this, that, and this with this case on this thing. So you guys are harassing and threatening me with this letter, and I want to know what brought it on.
All right. Have a nice day, sir.
I promise you.
Greetings and salutations. Welcome back to the Legal Beagles. Today we have Justin Riddle, who is the victor in the Nebraska Supreme Court in the oral arguments you saw last week. And we have him here. Welcome, Justin. How are you doing today?
Doing great. Thanks so much for having me.
Absolutely. Good for you to be here. And so how did you get involved in the charter? How did Charter West start suing you? What happened here?
Well, I know that a lot of you, especially if you're watching this, have dealt with a lot of situations with where something very simple, or it seems very simple, yet every single person you're dealing with or you run into that has any authority or ability to fix that simple issue chooses not to. And so what starts as basically, hey, I just need this corrected, turns into like, what do you mean no? And then it's like, wait, what do you mean they could say no? And then it's like, wait, what do you mean they can say no? And what you end up with is this convoluted process, which pulls you from just being a normal person that just thought, hey, if, I assume anybody that's watching this has probably experienced something similar to what I have that put them in a reason that they might be interested or following along. But, the bank, when we decided to change from one lender to another in the middle of our loan process, which technically we just did not mesh well with our mortgage officer. And so we said, hey, can we work with somebody else? And they said no. And we said, okay. So we decided to put our business to someone else. Well, when we did that, they went in and changed a form, changed the document. Like it's crossed out, and then there's a check and a circle. And if you look at some of my other videos, you can see it. But um, like this isn't subjective. They went in and changed it and said that I did owe child support instead of didn't. Right now, they were going off an old um, order from 10 years before, but I had well, custody of my daughter for 8 years. And it was even mentioned in the exclusions of the document. So, like, what they did was they did that so that the next lender couldn't do anything that they owed money to the government. And so I had to wait 12 months before I could then reapply for a loan. So, I thought, okay, well, first thing when I first found out, which was pretty quickly, I think it was within 30 days of removing my business.
Why don't you tell us, let's start again. Why don't you tell us how to find all your other videos? I think you have a YouTube channel. Do you have anything else? Charterwestbank.com, right?
I do own charterwestbank.com, though, in an effort to make it easier for people to find. I also bought the URL
Okay.
legalaid.com.
Goal aid?
Self-legal aid.
Self-legal aid. Okay.
Yep, because it was the easiest thing I could think of that somebody could, and the site is not wonderful. I haven't spent much time on it because I've been doing other things with this more recent stuff. But and then at the pro se or pro se selflegalaid.com.
Selflegalaid.com. And then you have a YouTube channel under, is it your name?
It's actually at the pro se at the pro -se.
Okay.
And if you find that video that you watched, you can click on it too, and it'll take you to my other videos. And although I will be the first to admit that I don't have a very consistent way of delivering my videos, in terms of some are just like a picture with my voice, because I essentially, what I'm doing is I am building a record that can't be impeached. And so when I'm somewhere, I'm recording what I'm saying with them. They know that I'm videoing them most of the time, because they're like, oh, you're videoing again. It's like, well, of course I am. You guys are lying. What do you want me to do? I mean, when you're lying, I have to protect myself by showing that you're lying. So that's what I'm going to do. I don't care if it makes you uncomfortable or not,
Right. I have a right to record in public.
Yeah. Well, and I'll record in their office. I mean, at the end of the day, what they're saying isn't true. And so I want to make sure that I can prove it, and I don't want it to come down to my word versus theirs. They can have hurt feelings all they want, but they're trying to hurt our feelings.
Yes, absolutely.
Yeah.
And so the charterwestbank.com URL is the subject of your oral arguments that we heard last week, right?
It is.
Okay.
It is. And effectively, I can skip kind of ahead after, basically losing on lies and silly procedural tricks that really don't apply when judges do their job properly. I thought, well, I can't win in court, so I guess I'm going to have to buy a gripe website. And I just initially set out thinking I would get like, Corrupt Banks Nebraska or something like that, which I bought a few like that. But actually, the first website I bought was charterwestbank.com, because I was trying to find something similar to Charter West Bank and couldn't believe when it popped up as an available option on GoDaddy.
Right. That is kind of crazy.
Yeah, they have charterwest.com. Apparently, they hadn't in 20 years decided to add that little bank part to the end. Well, as soon as I bought that, I let them know that I bought it and that I was going to set up a Gripe website, which I did. I mean, it was even less quality than the one I have now, but I set it up so that it was clear that I wasn't the bank. It was a Gripe website. There are no ads. You get what I'm saying? Like,
Yeah.
I have never put an ad on that site or anything. It's never generated a dime. Nothing about it, because it's purely a site to Gripe. And so I didn't want them to have any technical aspects that they could.
Yeah, which is an element of what they would need to prove that that you couldn't have it.
It's one of them. Yep.
Yeah.
And on its own, I don't think, like, having an ad on the site, for example, I don't think on its own that could have actually changed anything, but I don't want them to have any opportunity. I think while we're on the topic of the opinion of this, I want to point something out so that people understand just precisely what they're up against.
Okay.
So the opinion, if you cut it down to what actually mattered for purposes of did I or did I not violate the law, the way that it was broken down by the justices was that at the end of the day, since they didn't have a trademark or a copyright or any type of service mark that was worldwide known and actually registered, which was silly, but they also didn't have the website, so big surprise, right?
I mean, that's very sloppy on their part, I think.
Well,
right?
both parts, right? I mean, It's in 2017, you don't own charterwestbank.com and you're Charter West Bank. I mean, and you don't own Charter West Bank as a trademark, but the justices actually broke it down as follows. Although, we believe that the bank has satisfied this, and this in terms of being well-known or recognized, when we break it down to Charter and West and Bank, there is no way that those can be determined distinctive, and therefore we have to rule in this favor, right?
Mm-hmm.
Well, I want everybody to understand that the justices, and it's important to know the distinction between a judge and a justice, because if you don't, and you're up there talking to them, they're probably going to frown. But, the justices, they could have stopped at Charter West and Bank. They had every ability to do that. If they wanted, in that situation, for everything to just operate as it had, they could have just said, but Charter West is well known, blah, blah, blah. So we're going to say we affirm the lower court. Now, there's two possible reasons why they broke it down to 3 words instead of just leaving it at Charter West and Bank, or altogether Charter West Bank, right?
Mm-hmm.
One is my belief, which is they're actually really good. I look at the opinions of higher courts, and ones that are public are typically pretty good. Ones that are public. Ones that are done in the shadows, like most of us would deal with, are usually one-sentence affirmations of the lower court without ever addressing the merits or substance of the argument to begin with. But, I think that partially it has to do with that they're good. The second part is I put a trap effectively in there by pointing out that every single person in the state, in the industry, in the courts, in the bank had all lied. And it was so simple that all they had to do was look at this one single document right there, which they had, and they all just pretended like that didn't matter and lied. I mean, this is not rocket science. You cannot modify somebody's mortgage form after they've left. You just can't do it. There's no initials there, but there was an X and a line for it. I mean, it was that obvious. And so,
And you're talking about when you wanted to not have the representative that you had with Charter West, they said, no, there's no one else you can work with. And so you dropped them as a lender and moved on, and they were upset about this.
that's why they changed the box. Yeah, like petty. I mean, and you have to understand when you're trying to explain to a normal person, no, I'm not kidding, guys. The bank lied. They changed this form, and now the state is lying, and the Federal Reserve of Kansas City is lying, and the Consumer Financial Protection Bureau is lying. Like, who's going to believe that? What the thing I always heard, like even from people that I know, well, why would a bank lie? Because they were mad. But why? I mean, how does that? Like, you got to remember, we're still dealing with people, you know, and people are people, and they get away with doing things because they don't get confronted or caught, or nobody can combat it, which I've learned the hard way I mean, you have to remember, this was in 2016. So I just argued last year in front of the Supreme Court of Nebraska, right? But by pointing out in that argument, which is why I made sure to reserve that time at the end to say, you know, every single person was either completely incapable of doing their job or they lied, you know? Now, by agreeing that they didn't have a trademark and didn't have any legal right to it, they were like, they didn't have to address that second part of my argument. So I put that in there because I knew that if that they wouldn't want to address that. And can you see me?
Yes, you're back. You dropped off there for 1 second.
Yes. Yeah, I don't know. The whole screen went dark.
Yeah.
But yeah, effectively, they had to rule in my favor on what I was saying about the copyright issue or trademark, or I'm dealing with a copyright issue on something else. So but otherwise they had to address the court bias. I knew they did not want to address that. So I felt like I had set myself up for a win, but that's why I made sure to state, like, something else I should point out. The reason that video does well and that you guys like it is because I was able to tell the story. I was able to start here and keep moving this way. And when the justices were asking questions, I was able to address those and then pull back to where I wanted to be. I put it back in my wheelhouse because I wanted to make sure certain points got out, period. Like, win, lose, or draw, I had to get those messages out because that was the problem, is everything gets hidden away. And the people that we're fighting, I don't know about you, but if you're fighting without an attorney, what you're fighting is everybody. You're fighting the state, you're fighting the court, you're fighting the attorneys, you're fighting the original organization. You're fighting everybody because it's a big club and the price of admission is a law degree and some privilege.
And a bar license.
And if you don't, yeah, this is true. And if you don't, they will do anything they can to insulate themselves from the scrutiny or from anybody from the outside being able to make it through the mud. I mean, they just fill you full of mud and quicksand, and you're walking through there thinking like, oh man, we started off, on a beautiful, sunny, sandy beach in Florida, and now we're on Omaha Beach. What happened? You know what I mean? Like, all of a sudden shells are flying and you just, and the reality is that I would venture to say that most people in a situation like mine, and so I venture to say a lot of people that have that participate with you and have watched did not start out thinking they were going to be a legal crusader. They started out having a simple question, thinking like, how can you get this wrong? I mean, the proof is here. It's here. It's here. I mean, we're not talking rocket science. And it was not until, you made the decision like, okay, I get it. This is how you guys want to operate, but I'm not the right person to do that with. But at that point, they're like, well, we're so far in, we're not stopping now. And it's like, but don't you see, I'm not stopping either. And they're like, oh, no, we're definitely not stopping. And it's like, and that's when everybody is coming. Then you realize the judges will, I had, not to get too far off topic, but I had a hearing on the 1st. I filed the case on August 12th, right? They had filed nothing in response. I filed an emergency petition, which they finally set up for October 1st. On the 30th of September, the defense submitted a motion to dismiss through email to me and the judge, which I never agreed to service through email. I mean, I would, but I didn't.
And you weren't an e-filer, right? You don't e-file with the court?
In federal, I do, but in state, they don't allow you to in Nebraska, which I'm addressing in my current battle.
Gotcha.
Yeah. So, well, but not only that, the hearing was in less than 24 hours. And in Nebraska, you get 7 days. You know what I mean? Not only that, you don't get 48 days to submit your motion to dismiss. That it was past due, but we can get into that kind of stuff later. But in any case, so we go into the hearing, and the first thing the judge says is, well, I need to look at this motion to dismiss and make sure I've got jurisdiction, right? And then she goes, they go through their 3 things. And so we start with number 1, and it was her issue of jurisdiction regarding a mandamus. And I said, fine, let's drop that out. That was for the federal court anyways, but I brought it here because they sent it back and said, file a case. I didn't want to spend another $500 to file one thing, blah, 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 blah. I said, but you're right. I said, look at the top. It says it's for the federal court. It wasn't even originally for this court. Kick it out. She agreed to kick it out. Mm-hmm. I went to number 2, which was they had said I didn't put anything about the situation of my own. I had just put the situation for my wife and my mom on their requests. They said, right here, it's the first thing, number 9, right here, exhibit 5. Well, those exhibits aren't in evidence yet. You have to get those entered. Sure. So effectively, then she just stopped me, shut it down, dismissed it without prejudice, wouldn't allow me to amend. But in Nebraska, you're required to file, if you're a moving party, and so that everybody understands what I mean when I say that, by moving, that means that you're filing the original document of whatever that thing is that you're trying to do. So like,
right, you brought the motion, you brought the action.
Yes, their motion to dismiss, they were the moving party. They're required by Nebraska law to request their own hearing. Now, the judge could combine it with my hearing, but they can't come in and make that hearing for an emergency petition a motion to dismiss hearing, which is exactly what they did right off the bat. They just can't do that. Now, did it matter? No, it didn't matter. And she also said that I didn't have the documents verified, but state sealed documents that come from the Attorney General don't need verification. It's spelled out really clearly. So effectively, she lied. Then she dismissed it right away and closed the docket, so I couldn't even put a response to their motion to dismiss. You know what I mean? So I refiled.
Yeah, normally what we've seen is people file the motion to dismiss, and then the judge, the court, and the other lawyers go on vacation, and they just sit on it and just let you, toil away, and then, you have to actually, they always say don't advance your opponent's case, but in some instances you want to file that motion to get it over with. But in your case, they just, we'll hear that too. Why not?
Correct. Which is, you know, here's the thing that everybody should understand, especially if you're newer into this and you still feel like, no, I've got all these facts and they lay out so perfectly, anybody, you know, even a caveman could do it. That doesn't matter. It
Yeah.
truly does not matter. You know, the judge can literally do whatever they want when you're in that courtroom, in particular when there's no cameras, no anything, you know, if it's not some publicized thing. But if they decide that they're going to just ignore every single bit of law, they can. Now, there are ways of filing the complaints, but what I found out recently is that, like in Nebraska, the number for judicial complaints, that number doesn't even actually exist. I mean, you call it and it goes to a voice mailbox for a probation hall or something. It's like, and there's no, and apparently when I call the other number to get another number, they say that, well, you know, nobody really staffs that area. They're only, well, how do they get there, man? Who knows? So it's kind of a Kafka's nightmare where you just have no.
Right, and so let me. We've had so much technical difficulties for everybody to know to get involved. We forgot to mention that what you heard at the beginning of this video was a conversation with Mark Weber, which was the disciplinary, the head of the disciplinary committee for the Nebraska Supreme Court, and so you confronted him and asked him for the evidence, and of course he ended up hanging up the phone on you. But tell us a little bit about that.
Well, so the day after, and actually that hearing I was just telling you about on the 1st of October. So, and in retrospect, you know, you learn things because if you've done this long enough, or if you've dealt with the courts long enough, like with me, they send me anytime they're doing something that they know is terrible or wrong or going to be aggravating to me, they make sure to do it on my wife's birthday or Valentine's Day, or April Fool's Day was a good one.
Yeah.
That was an original Charter West one there, April Fool's Day. You know, and so on October 2nd, when the judge then formally dismissed the hearing from the day before and shut everything down, that's the same day that the UPL, or unauthorized practice of law, sent that letter. Now, I can tell you I wasn't looking, but I saw it on social media somewhere, and then I like verified it. October 2nd is Nationally Wrongful Convicted Day. National Wrongfully Convicted Day. So
Wow.
in my mind, there's no chance this was a mistake. Like they, you know, they just do this kind of stuff because they can. Because one, if I'm being fair, there's so much to understand with the law beyond right and wrong. Like, yeah, right and wrong. Most people can actually know right and wrong, but we also know that people have walked in murder cases where everything seems to be clear. We also know, you know, people like Carlos de Luna had been convicted when there was nothing.
Mm-hmm.
So, you know, yeah, I have ADD. Did I mention that?
What, Carlos
You get
no.
used to it.
No, Carlos de Lunas? No.
Well, yeah, de Luna, I mean, that was a bad situation. You guys can all look that up. But, you know, it's just what I've come to find is that the system itself is the problem, because when you have a bank that can lie, or a school district like what I'm dealing with now that can lie, the attorney general can then publish a lie. The ombudsman can ignore the lie and tell you not to come back. The judges can dismiss the case on technicalities that, although real technicalities, did not apply. They just weren't, like, yes, certain things do need to be verified, but not these, because they were official documents. So you can't dismiss it on that, even though you did.
Right.
You know, taking their motion dismiss.
Yeah, like you were saying earlier, the AG stamp on a letter to the court is a self-authenticating document, so it's automatically admitted as
it's spelled out very clearly in the statutes, and everybody should understand that if you're in state court or if you're in federal court, you need to look at the actual statutes of things, not just the Cliff Note statutes that come on some of the websites that give you a little bit, because if you look at them in their entirety, there is a lot in there you can find. I mean, the mistake that these folks keep making is that I've been right every time and I've got all the evidence, and every single time they make me jump through another hoop, I learn something. And that thing makes it harder the next time, right? And so you take this situation, for example. Well, now I know about the fact that they have to request a hearing of their own. I didn't know that before because it's never come into play. I didn't know that all these certain documents were self-authenticating because technically the judge was as confusing as you could be when she is trying to tell me that she can't teach me the law. And I want everybody to understand something. The most aggravating thing you will hear from everybody in the business, from people that literally don't know anything about the law, like somebody, all they do is like get coffee for somebody in an office with attorneys. Like, they're not law students. They're like, I'm sorry, I can't give you legal advice. It's like, I know, I didn't ask for any legal advice, you know? I mean,
That's a tactic they like to use so they can shut you down. I mean, that's all that is.
So on Monday, when I went to drop off that Supreme Court petition, I went in there and the lady says there's a fee. I said, okay, how much is the fee? She said, I can't tell you. I said, what do you mean you can't tell me? She said, I can't give you legal advice. I said, sure, but like, can I just pay it? And she's like, yeah, you can pay it. And I'm like, okay, how much? She's like, I can't tell you. You have to go look it up. I'm like, I said, what? I said, well, where do I pay it? She goes, here. I said, I've got my card in my hand. She goes, yeah, we don't take cards. And I'm like, I said, okay, I'll go to the nearest ATM. I have all this on recorded as well, so I can send it to you. I probably have it. I don't know if I put it on YouTube. I said, okay, I'm going to walk to the nearest ATM. How much do I need to withdraw? She goes, sir, I can't tell you. I can't give legal advice. Then the Capitol Police come walking, and I'm like, guys, because they know me well by now, because I've been trespassed from the Attorney General's office, you know, and every time I go there, they get involved. I said, guys, I know you're on their side, but I said, this one's crazy. I said, I'm trying to pay a fee for this document that she has back there, you know, because she took it. She won't tell me how much to pay. And I don't even think they quite understood how ridiculous it's getting at this point, because they're like, hold on, let me listen to her. That's what they always do too. Everybody always wants somebody else that's smarter than you to actually say what's going on before they know. And I'm like, but she's not saying anything. I said, and then this other guy comes forward and he's like, sir, you just need to take a few deep breaths. I was like, sir, you take a few deep breaths. I was like, I just talk like this. This is how I talk. I said, I have my earpiece in. I took it out. I was like, sometimes I talk loud with that. And I was like, why are you out here patronizing me? How much is the fee? Well, I can't tell you that. Then why'd you come out here? So ultimately,
I guess that was a tactic to not get you to file the document.
Okay. If you want to deeply analyze it, here's why she did it. My opinion. Because when I walked in, I was like, there's no fee for this. I was like, I've looked really carefully. There's no fee. Now, had I looked really carefully? No. I didn't even care, because I'm filing it on top of an action that's already existing in court. But since I looked really carefully and couldn't find anything, which is how I presented it, once she realized there was a fee for a mandamus action, which is its own original thing, she didn't want to tell me the fee because she figured I'd have no way to find it. Because I had looked so hard, like I'm guaranteeing you this is why, because she thought, well, this guy doesn't know the fee, so if I don't tell it to him, he can't even file this. Because I pointed while we're standing there, while the cops are standing there, I'm like, this says fee right here, 25 cents a copy. She's like,
this is a complaint, or this is our judicial complaint or disciplinary complaint?
No, it's a writ for mandamus.
So you're at the clerk of the court. Their job is to tell you that.
Yes, dude. I will make sure you have this video. I wonder. I don't know if I uploaded it, but
send it. I'll stick it in here. Yeah,
I will. Oh yeah, I do have it in here. It's 24 minutes long. So I'll send it over to you.
Maybe I could dice it up or put it at the end or something for people that want to listen.
Yep. So So yeah, it took me about 8 minutes of that was just me asking her to tell me the fee, and then finally the guy comes out and he like slides a piece of paper over to me, and I pick it up and I look at it and I say, okay, it's $100. Like, okay, $100. And then they had an ATM inside the building that she didn't want to tell me about, but the cops did because they like me. They do. And they also know the truth, and they also know they aren't innocent because they aren't standing up.
Right.
And they're, you know, they haven't like, they don't lay hands on me or anything like that. They like me, but every time they come to a situation, it's because my voice is the same as it is right now. And in that place, which is an empty bunch of halls, it sounds like I'm using a megaphone and shouting through, you know, because it's just like, you know, it just, everything echoes, you know. But so they come in and they're like, oh, geez, this guy again. They're like, Justin, you know, but at the end of the day, they also recognize, because I've sat there and I've walked them through the evidence, that, hey, here's all the facts, here's all the evidence. That way, when I've been when I was trespassed from the AG, and I was like, I'm going to make you guys arrest me, so I'm going up there, but I let you know I'm here. Here's all the evidence and why I'm going up there, which I did, and they didn't arrest me, because then I would get the discovery they're trying to avoid, because I'd be like, here's why they did it. You get what I'm saying? It's like this whole...
Yeah.
So that's the other thing. If you are completely correct and you're dealing with a situation like mine, they can't do anything to you, because if they do, you're guaranteed to get the discovery in the situation that you wanted originally they're trying to avoid. So they puff up a lot. But in any case, yeah, back to the UPL. So that came on the 2nd, right? That was sent on the 2nd. But I was out of town until the 7th. And so when I got back on the 8th, I started calling. I got this letter and I started calling. I said, hey, you know, well, actually, I only got a hold of the guy once, because other than that, he just won't answer. And listen to this for 1 sec.
Multiple times in courts, what we're dealing with is it's a barrier.
Here, hold on. Sorry.
So I gotta go look at the rule to figure out how much to pay you? This makes no sense to me. I'll pay you the fee. What's the fee? How much? Who am I supposed to pay? Hold on. Who do I pay? Where do I pay it? How much do I pay? How am I supposed to pay something? I've got my card out. How can I pay it if you don't tell me the fee? This makes no sense. Cash or a poverty affidavit. You're sure about this?
Yes, I'm sure. If I have no ability to pay the card,
I mean, I'll walk up, I'll drive to the nearest ATM and grab cash. How much should I withdraw? I've never heard of it. How can I not know what I'm supposed to pay? I brought everything in. All I need to know is the amount. Hold on. You take a deep breath, sir. You're not trying. Tell me the amount for the fee. I mean, I'm a normal person asking to pay a fee, and she's saying, go refer to the court records. I can't tell you the fee. I've never experienced that ever. Every time I've ever filed anything, they go, the fee is this, the fee is that, the fee is this. So why did you come out here, you know, patronize me like this? I'm super confused. Are you at this department? I feel like you are, because you haven't told me the fee. Well, sorry.
Well, I won't. Yeah, that's when I took my earbud out. But do you see how accurately I just described that situation?
Yes.
This went on.
Yes.
I mean, now, do you know why? Oh, well, I think I told you why, because I'm sure she's convinced. Yeah, well, and she also thought I couldn't find the fee. It's like, did you see the brief, lady? Yeah, you did. Your eyes popped out of your head. I think I could figure out how much to pay. But on principle, you need to tell me.
Well, let's say I have $200 here. What change should I expect back?
Well, and I even said to her, okay, will you take any amount then? I'm going to just come in. I'm going to set some money down. Is that just going to be acceptable? You know, eventually that guy came back and slid a piece of paper in front of me like, here. It's like, how hard was that? By then the cops were already there and just like, I think they're just bewildered that I'm not actually the psycho that everybody makes me out to sound when they call security going, oh gosh, this guy is here and he's being loud and threatening and disruptive. It's like, if you get gaslit enough and pushed in the wrong ways, you're going to sound disruptive. Like all I'm asking, like, how many times do you say, I just need the number so I can pay it, before you sound like you're crazy? Because they're just like, sir, why would you even ask that question? I mean, this is silly. This guy is crazy. And this is what I deal with. This is like, so to people that have,
and you're not alone.
You know,
you're not alone.
Well, and that's what I'm saying to people that know it's the norm, not the exception.
Mm-hmm.
And that's why, you know, anybody who intends on taking on litigation themselves better expect a few things right up front. One, you better expect that most people aren't going to understand or believe what you're saying. Even if they believe you, even if they trust you and love you, they're not going to understand, because something about what it is that registers to you doesn't register to them the same way, whether it's because they weren't the ones that were victim, or like in my case where people are just flat out like, why would a bank lie? It's like, I don't know, because they were mad. That sounds unreasonable. Well, why wouldn't this department, the banking department, why wouldn't the AG? And once everybody else that is supposed to make you correct by doing their job and proving it says that you're wrong, then nobody believes you, because all of a sudden it's like, well, nobody. Then you go and here's the ruse. So you go to one of these state departments, Department of Banking and Finance, or you know, the Attorney General or the Ombudsman or whatever, and they're cozy with whoever it is, whether it's the attorney for that place or the company or entity itself. And basically what they're going to do is find a way to make sure that you look wrong, so that then they can go into court and say, well, look, we don't even need to, you know, they can file a motion for a summary judgment, because they can say, this has already been investigated by the state. There's no need for a judge here. We've done a full investigation and here's the outcome. So now your proper steps of first asking whoever wronged you to fix it, then, you know, going to whatever entity that you felt like was the next logical choice, whether it was, you know, you know, somebody like the banking department or some consumer department or whomever, and then going, say, to the AG or the ombudsman after that and saying, hey, I'm not getting, like, you're following the right steps, but what's happening is you're actually knocking out the pins that are holding the cage around you, and it's about to collapse down, because what you end up with is a perfectly documented record of you being wrong according to everybody that matters. So first and foremost, when you're going to take on litigation like this, you need to have real evidence, and you need to have real proof, and it needs to be unimpeachable, and it needs to be clear. Because I've talked with people, and a lot of people, and sometimes I hear things and it's like, yeah, I get it. I agree with you. And I, as the, you know, pro se self-help guy, I feel very strongly about everybody winning, right? That being said, if I take what you're saying, you're telling me that I, as a juror or a judge, would just have to trust you or just trust them. But all these things that you're saying, you really can't substantiate, which there would be ways if you had done these things along the way, or if it were completely true, or if there wasn't some, you know, and so a lot of times I feel bad when I say to people, you know, at the end of the day, trust me won't help in court, or take my word for it, or I'm really honest, Your Honor, or this, you know, that will not work. You're in a situation as a self-represented litigant where literally you can not just have a smoking gun, but you could have the picture of it leaving the chamber, frozen in a millisecond, coming out with it still in the hand,
Yeah.
in your hands as you walk into court. That's still not enough to get past their games. So
You're right. That's a very good analogy.
I mean, it's just the truth. When they say my website is unauthorized practice of law, because what they said is they have a complaint and documents, which doesn't exist, because there's nobody would have documents that I created on their behalf or to help them with some case. I just haven't done that. Right.
Right.
And so, when they say that, and I know it's not true, I can confront them and say very clearly, like, no, this can't be true. Well, it's your YouTube videos and your website. It's like, dude, I mean, saying that my website is the unauthorized practice of law is like saying that Rachel Ray is practicing medicine without a medical license because she's got a recipe for chicken soup on her website. I mean, it defies logic. It's like saying that someone learning CPR is performing surgery because they're doing chest compressions without a license. I mean, it just makes no sense. My website is not that good. I'm trying, I'll get it there, but it's not that good. And as much of a compliment as it is for me to know that they're terrified of what I'm bringing to the table, what they did is they flatly lied. They said that they have something that does not exist. It can't exist. I would have had to have been a party to it. They know it doesn't exist, which is why when I sent the Freedom of Information request, which on that note, those are your best friends if you're dealing with anything government related. Now, I want you to think about something here. You could be suing Pepsi. Can you do a Freedom of Information request to them? No, because they're a company that doesn't owe you anything. But when you have the Attorney General or the Department of Banking and Finance or this, that, or the other government agency do an investigation, you can Freedom of Information Request Act that. And in Nebraska, and it's not the same everywhere, but like those lawsuits are required statutorily to be basically prioritized above any other hearings and expedited in every possible way. Now, what does that mean to me? 40 days, according to this most recent judge. You know what I mean? Because that's just the fastest they can do it, right?
Mm-hmm.
Which is why, we ain't going to make it 40 days because I have other things that I'm doing concurrently. But the point is, Freedom of Information requests, those are your best friend, because here's what it gives you. It gives you a free shot at a suit that doesn't affect your underlying suit. It doesn't change what you originally sued for. It's separate. I'm suing for these records because of this, right? Well, that doesn't change anything. So even if for whatever reason your FOIA suit gets dismissed, it's not going to affect your underlying case. But, if the law works the way it should, which it often does not, as we've all learned, then it may get dismissed. But if it doesn't, then you're probably going to gain the information that then takes the company to the point where they go, okay, maybe we should talk, right? And so that's a critical point. But in any case, when I FOIA'd the records on the complaint and the documents, they're pulling executive privilege and saying that they're not going to turn over those records to me, which of course they won't because they don't exist. But as we know, due process says if they're going to accuse me of something criminally and they want to try me, I get to see that, which is why they won't try me, I'm sure.
Right. Well, we'll see. But yeah, it's funny that all these people think that the city and the state have proprietary information that you can't have. No, right. It's not owned by you at all. At all. It's owned by us.
No. Yeah. Well, and here's the thing. The difference between me and, say, the attorney for the schools is they got all that information because they're an attorney. It went to them. Me, though, I'm as a citizen. I just...
Yeah, you said schools. I don't know if we've really gotten to that next lawsuit yet, but first, would you tell us how did you prepare for the Nebraska Supreme Court? You know, you did sound quite polished, of course, and
Yes.
we just wanted to hear what you did to prepare for that.
Well, I would say that the biggest advantage I had was when COVID hit, because of the non-essential nature of my case. It really got back burned, right? And so I had like 3 years. Now, I spent that first year basically de-stressing from the previous several years of fighting nonstop in court. But then I spent the next 2 years just basically learning specifics about exactly how I wanted to present it, right? So I had a lot of time to lose the rage. I think that's the time thing that I'm talking about here. It's not so much that of what I learned in that period of time. It's that the rage was gone at that point. You know what I mean? From 2016 to 2019, I was flaming hot. But I mean, you can imagine, right? But by the time the actual hearing for the Supreme Court came around, the anger was gone, and it was just resolved. I knew. Now, I will tell you, before the Supreme Court hearing last year, back in 2021 is when the school issue started, and I deliberately waited 2 full years until after I won that case in the Supreme Court to come back against the schools, because I felt like, well, at least then this way I'll have a little bit of clout or merit. That doesn't matter. In fact, I think it makes it worse, because they're like, take this guy out. You know what I mean? But so essentially how I prepared at the, for the actual hearing itself is I determined what I needed to say first and foremost, because as when you get there, like I had watched, first of all, read opinions, watch hearings with panels of judges that you can, and you'd like watch that stuff. You can learn a ton that way. Once I knew what I needed to get across, I wrote it all out, right? Then I started changing how the wording was so that it flowed a little better. And because this was before AI, so it was just like painstakingly I'm changing things over and over. But I probably spent 3 to 4 weeks straight, almost all day, every day, just working on exactly how I would get that message across. Because at the end of the day, I needed certain things to be stated so that people knew what happened. Because the only way people can ultimately understand the problem is if they understand how simple the actual issue was. Is a single document was changed. But somehow, a bunch of high-paid people that have great jobs in the state that, they can't read. They could, either they can't read or they're unqualified or they're lying. Which is it, So once I knew I had every key point in, I then made sure to separate them into segments so that if they asked questions that threw me off, I could skip basically right to that next segment that they were, because I knew what they were. I tried, like, I have ADD and so ADHD, and so like my brain moves in 1,000 directions at once. But ultimately, what I try to do is anticipate every single thing that conceivably the other side could say or come up with, or that might be asked. And I think I anticipate everything except for the simple, like when they're asking me, hey, this court, that court, because my brain's like, and at the time I'm not thinking, oh, federal, civil, 8th Circuit, whatever. And so it sounded right off the bat like I didn't know what I was talking about, but really I was just headed this direction. But, I wanted to make sure that if I had to skip something, I knew exactly where I wanted to go then next and what I would skip by the way I broke it down. Because at the end of the day, I was going to keep those last 2 minutes just to basically point out that the whole system failed in a massive major way. And it wasn't a failure, it was a structure. It wasn't a random happenstance. It's just the way that business operates. And there's no disputing it now with what's happened since then with the school district and the AG and the.
Right. So you mentioned AI. How did you implement using AI, and what AI do you use?
So it's hard to give a simple answer to what AI I use because there are different reasons to use different AI, but the best AI by all anybody that says otherwise just doesn't understand what they're looking at yet, and that's cool, but is Claude Opus. There's an app called Poe, P-O-E. I highly recommend that people download it because it includes basically every AI on the market. If you look at some of my YouTube videos that have pictures on them that are clearly not me, but look real, or they're, something, whatever, it's just me telling the AI, hey, make a picture of this, and it just pops it out, and then I just use it. No, then I don't have to worry about finding things, copyright issues, or anybody coming going, hey, that little, scales of justice you have on your website, I'm pretty sure that was from our webpage. Okay, whatever. You can just make it all, but so effectively, here's how I use AI. And when I tell you that what I can do with it is replicable, but I don't know how many people will actually do that because a lot of times people they'll give the AI information and then they kind of want the AI to just work it back through, right? What I do is I first of all, I start with the briefs or the complaints that I have from now or in the past that are the most clear and the most damning, because when you show Claude Opus really egregious violations of law, it's like actually annoyed. It's like, this is crazy. You know what I mean? And so then you have an ally. And when you have an ally that's the, equivalent of every scholar and lawyer and whatever in the history of Earth, you have a tool that can write things for you in a way that you can't do, period. I can't, you can't, attorneys can't. My briefs look better than attorneys, other than sometimes like I forget to put page number, like ADHD, dude. I literally, I can't remember the last time I put page numbers on them, and they want to complain about it. And it's like, your machine does it when you scan it through, cry about it,
Right.
So,
Exactly.
Yeah. Right. So,
but it's the court rules, and we have to pounce on any technicality that you didn't perform, and that's going to be our evidence why it shouldn't go forward. We're not worried about merit. We're worried about technicalities here, which is why they brought you to court in the first place.
Right. Which is also why I didn't just win and get the stupid checkbox changed. You know what I mean? Like, crazy. But I will spend the equivalent of, let's say, 10 hours to create a brief, right? Now, like, because I have so much built up that I can feed it and say, taking this point, this point, this point, and this point, let's do this. But in that 10 hours, I probably create, I would say, 40 documents, 50 documents, right? And each of them is probably an average of 3,000 words, because it's me having a conversation with AI saying, okay, what about this? What about this? What about this? What about this? And because you end up eventually running out of room, which I use the large context window AI, which means, some of them, like the basic ones, may have like 4 or 8,000 context window, which might be like 20, 30,000 words. The ones I use have 200K or a million, which are in Poe, and it's $20 a month for the really good bots. So, I mean, it's worth it. But so they could technically have, like, some of them I can have a conversation with for, 400,000 words. And so by the time we've gotten through all this, I have them distill it all down. Then I take that again, and every time I respond, I save it. That's why I think I sent you the other day the untitled documents, the page of untitled documents.
Yeah.
I mean, I have over 1,000 of them just since July. That's their name, untitled document, because I take them, I paste it, and I don't save every single one because sometimes I forget or I just read it instead, but I play it so that I can listen to it because it doesn't do that natively through the app. But at the end of the day, you take all this information, you have it distill it down, and then you take it to a new conversation, and then you have it start writing and putting in this, that, and the other. But what you have to remember is, I mean, what I can get accomplished, say in, let's call it a week, right? What I can accomplish in a week, I could accomplish without the AI, but the final product would be the difference between a soapbox derby car and an Audi. You know what I mean? Because
yeah, so you basically start with giving it some information, and then you converse with it about certain points, and it gives you feedback, and then you give it feedback from reading that, and then you basically channel it down into one document from all of this stuff that it created versus what you put, and so you go through a process of skimming it down. It's not just a one step. Hey, here you go, write me a summary judgment. You read it and then say, yeah, okay, well, we need these points and these points done. Right.
Correct. And to do it effectively, sometimes you have to have one conversation that's specifically about this document or this topic. Let's dig through here. One conversation that's this, one that's this. And then at the end, you take those three, you go to the new one and you go, hey, here's what we came up with. Let's put this together in a meaningful way, because what people have to remember is the only person that really knows your story perfectly is you. You're the one that's lived it. You're the one, and so even the most intelligent AI like Claude Opus, although I will just throw out for cost and context window, Gemini Flash 1 million is really good. And then Sonnet 200K, Claude Sonnet 200K 3.5 is really good. I mean, there's several, but Opus is really expensive in the whole scheme of things.
Mm-hmm.
So not everybody wants to use that as much, because when I say expensive, it's like you pay the same, but you get 7 messages per 8 hours instead of 40, which makes a difference,
Right.
So
yeah, and it's just so people know when you're dealing with AI, you're usually paying by the number of bytes you're using back and forth, right? It's so, like, for instance, I use Opus Clips for my shorts on here, and you pay for 40 hours, so I can upload 40 hours of video, and it'll give me shorts on those 40 hours. And that's, you have to, if you want to use it more, you have to pay more. If you don't use it, then
that would be similar in concept, except for really they have it kind of limited, so you can't use more.
Gotcha.
Like, I have 4 subscriptions, 3 to Poe and 1 to Anthropic, because Anthropic is Claude, but Poe has Claude and the others. So I am a high volume user, but at the end of the day, what I put out can't be questioned in any meaningful way, because if that question exists, my bot will pick it out before before I ever put it into the brief. I won't make that kind of error, because we've already stress tested all these ideas, and So it's
at minimum, it's a good way to see what the opposing counsel is going to say and what the arguments could be and might come up. And it thinks of a lot of things that maybe might slip your mind for the moment, and it might help you remind you of what you need to say.
not only that, but the elegance of the writing cannot be matched. I mean, Claude can write briefs in a way that literally look like constitutional documents. He could also write one that was just a total flaming somebody with cuss words and whatnot. Not that we would do that in this, but like the actual choice of words that are used by AI when they recognize that this is a significant legal, moral issue, it sounds like Thomas Paine wrote it. You know what I mean? It's so cool.
Mm-hmm.
And so at the end of the day, one thing I mean, I would rather just go into court and argue everything out in front of a judge if it was me and like an impartial judge. But some people like writing and doing all that stuff. I don't, I'll do it because it's a necessity, but I don't.
Yeah.
So instead, I just give documents, give evidence, talk to my AI, and then let it make the thing. And then you always have to read everything. You got to make sure dates are right, names are right. Usually it gets it right. But if it thinks something different, it can make your whole brief based on one thing that it misunderstood or one person that wasn't involved,
Right. Yeah,
if you don't read it, because
you have to check it. You absolutely have to check it. And I'm sure that we're going to have a lot of feedback on this topic, and we may have to have you back to specifically talk just about how you use AI in the law, because we just had a lawyer on, and he's developing this type of thing, and there's some pitfalls and whatnot, but there I think I can see some advantages in it, but it could get dangerous. But
the key is that the key is this. Well, but think about it this way. I mean, it's dangerous for the system because it's an impartial arbiter, right? And that's what we really want, is we just want the truth. Like, I'm amazed at how many people that I talk to that face similar things like me, that I want to win my case or whatever, but really all I want is a fair hearing. I just want the truth. I just want to be treated fair. I just want it.
Right.
I just want my fair shot, And so with AI, what you get is a neutral viewpoint, right? The problem is when people fail to remember that AI isn't you. And if you don't follow through and review and look at everything it's doing, things will go in there that aren't correct. Or, I know everybody's worried about, it's going to cite the wrong, like false fake case law, which actually one of mine did earlier this year. And of course, of the 40 in there, the trolls online are pointing out, oh yeah, what's this case here. And I'm like, I don't know. I didn't notice that one. And so then I'm like, hey, did you give me a fake case law? And the bot's like, oh, well, yeah, my bad. I was getting carried away. And it's like, don't do that, So, but now a simple request of, when you're doing it, saying, hey, make sure you only cite real case law. Do not make anything up. That solves it.
right.
I mean, that's it. You just don't tell it and it does everything, though. It's a process.
Yeah, absolutely, and that's something everyone needs to learn, and they need to know what they're doing before they ask AI to do something for them. Otherwise, you're going to get caught in a oral argument, and you're not going to know what's going on, and it's going to hurt you. But let's move on to your second case. You're suing the school, is that right?
I am.
Okay. What came about with that?
In 2021, my mom and I went to a school board meeting, and I had some recordings I wanted to replay. They were school officials saying things that, shouldn't be part of the curriculum, right? And
Okay.
So
you had a problem with the curriculum. Okay.
But it was the school, their videos from their online things that, I think they were supposed to be hidden away, but actually found them. And so I had it, right? And again, I'm telling you folks, if you don't have evidence, don't play this game. It's not fun. It's not fun if you have all the evidence.
Right. Exactly.
So if you have nothing perfect, don't play the game. You need to have something that's going to prove your case for you. So she went first, and they asked for her address because now a couple of years ago they implemented this thing where, oh, we want to make sure everybody gives their address so we can make sure they're intimidated to say the truth. You know what I mean? In a public forum, whatever. And my mom's like, well, no, I don't think my husband would appreciate me giving my address. And then the lady's like, well, do you work in the school? And she's like, yeah, 36 years. I was a teacher. I retired here. She's on, she's on their health plan still, the pension, everything. And the lady's like, okay, go ahead. And so she starts playing the recording. And as soon as they hear what's being played, they're like, and they shut her mic off. Man, nope, you can't play this recording, blah, blah, blah. So then I went up to try to help her. Because
this is in court, right? This is in court, or
no? This is at a school board meeting.
Oh, school board meeting. I got you.
Yeah, just a regular school board meeting. So they escorted us back to our seats, because that's just kind of what they did. And so then when I got up, I also refused to give my address, because I felt like it was a measure to chill speech. Sure. And they wouldn't let me speak, and then they had the police escort us out. Not because I was violent or anything, obviously. I mean, that's online too. It's like everything. This is the beauty of it all. That was a public school board meeting. It's all on video. So in any case, then the next day I got a call from the Omaha Police Department of Mental Health and Wellness, because they just wanted to make sure. They heard I was so upset, about the curriculum, that I just, want to make sure I was not violent, blah, 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 blah. And of course I'm like, buddy, who put you together? Like, do you draw the short straw or something? Like, I was like, they had you call me because none of them wanted to. And, well, that didn't work to chill me. So then I went to the next meeting 2 weeks later, had a bigger crowd, because at this point I'm getting people involved, right? And so of course made sure to give my address and follow the rules. And then there was a student that had been suspended for not putting his mask up fast enough between bites earlier in the year. And now we're talking in a cafeteria that everybody had their own table because they were, 100 feet apart. But nope, he didn't put his, he had it on, just not quick enough up between those bites. So he had found me online and reached out and said, hey, I'm going to come to the school board meeting, right? And just, kind of check it out. And so he sat near me, and when I got home, he texted me saying that the cops had already called his parents, saying,
"Ow."
Right. Then the next day, 2 officers showed up at his house. They wanted to search his room. They didn't have any specific reason why they wanted to search his room. Just, maybe there's something there, drugs or weapons or notes or something, right?
No reason. What can we trump up?
Right. Well, and then they told his parents they wanted to talk to me. So that got back to me. And of course I called that guy, and I have that on YouTube as well, recorded. And again, I'm like, I don't know what you guys are talking about. I'm just a normal guy. Blah, 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 blah. Well, at the end of the day, this guy also recognized that, no, I'm not a danger. He didn't even say I ever said anything wrong. There was nothing I said. And I was annoyed that they had gone and harassed this kid and his family because he had shown up, not even spoke at the meeting. Well, when that didn't stop me from going to the meetings and pointing things out, they filed a restraining order on me, the board president. So she cited the email that I had sent to the entire board saying, if you guys can't answer these questions and fix this, you will be met with termination and leprosy. Now, obviously, I meant their job and the inability to get another job, but they convinced a local judge that, oh, what I really meant was I was going to terminate the board president. And they went into court. And of course, I went into the hearing like, I mean, this is their whole argument is termination and leprosy. And that the first time when they tried to silence me, I turned around and addressed the crowd without the mic. I mean, like, and then of course their attorney started.
They love the Patriot Act. That Patriot Act is their most powerful weapon.
Oh yeah, yeah, yeah. Well, at the end of the day, their attorney said a bunch of things that weren't even true. She actually said that I was like the murderer, Kyle Rittenhouse, which, as we know, he was acquitted. And at that time, right. He hadn't even been tried yet. And I said, I objected, and I said, Your Honor, as you know, that's kind of a contentious statement because people that have watched the footage know otherwise, and this hasn't even been in trial. So how are you letting her compare me to this guy as a murderer? You know, but of course he let all that go, and he ignored the fact that the cops wouldn't testify, that they had spoken to, like, the cops didn't want to testify because they'd have to come in and tell the truth that I'm not a danger. And that right. would have undermined the whole thing. So, yeah, they got the restraining order against me. And I was like, okay. So for a couple more months, I went to the school board meetings because then she had to embarrassingly get up and leave the room when I went to speak. It was fun. It was kind of funny. And I pointed out every time how embarrassing it was for her to have to walk out there. But then I took basically like a year and a half off from that and started focusing back on Charter West because that's when I had that hearing coming up.
Right.
Well, fast forward to this year, I filed a suit against them. Oh, so at that meeting when they had us escorted out, turns out multiple members of the community filed complaints with the Attorney General's office because of our rights being violated, right? Well, the Attorney General sent it to the school district, and then the school district's attorney lied and said that my mom was silenced because she refused to give her address, which, you know, the transcript and the video and everything, there's no question that that's not the case. She was stopped because of the recording. Well, then the AG put in their findings that Miss Adamson's declined to give her address, but then was allowed to continue speaking. And then 2 paragraphs down it says, Miss Adamson was not prevented from, or was not removed from the meeting for was removed for not providing her address. Like it says here, she was allowed to continue, and then it says here, this is why, and it's the same thing. Like, no, they can't even mutually exist on this document. It's just, it doesn't scientifically work out. You know, either she was or she wasn't. Well, they know she wasn't, so they put at the top she wasn't, but then they put in their thing at the bottom that she was. Well, then they hid it away, and I didn't find it until I had already filed this lawsuit earlier this year against OPS. They didn't use it in their defense. Now, think about that. They had a complete exoneration from the Attorney General saying they did nothing wrong in this situation. That was the very topic of the lawsuit that I filed, but they didn't use it and say, Your Honor, look, the AG already said this, right? I didn't find it until like 2 months after I had already filed that suit because they drug it out. You know, they removed it, and then they got a motion for an extension, and then
all the yeah, and we lost you at extension, so
okay, yeah. So they got an extension, and and basically turned what should have been a 30, 40 day situation. It took them 72 days before they filed their motion to dismiss. Of course, I took that and then just dismissed the case without prejudice myself right away, so that I had all their work product, and then I reverse engineered it with my AI, and then effectively, like when I originally filed it, I filed it with like some sentences in there that's like, put your name here. So it looked like kind of a form, or like I wasn't all that sophisticated. I had a wrong date in there or one, just little things like that. So when they filed their motion to dismiss, they went all in. They wanted to show me what they were made of, which was what I hoped for and expected. And so I took that fantastic brief, and it was powerful. Like, it was different than what the bank used to file. Like, these guys are not on the same field. Like, Baird Holm and Jeff Silver, two different playing fields. But I took it, dismissed it, spent a few days taking all their arguments and just making, so that way, what I effectively was doing is I was using their own cited case law with proper rationale before they could use it, so that, like, if they tried to say this same case law like they did this time,
Right.
I've already put in there this case law, but with the proper rationale, so it just makes them look stupid.
Very clever.
So, right. Well, I mean, you have to take any advantage that you can. Like, professionally, it sounds kind of, crappy to take somebody's, 5 attorneys spent 72 days working on a brief, and I took it and just like dropped, but one, I wasn't giving the judge a chance to give them attorney fees, which they asked for in their motion. It's like, by dismissing it myself, they'd have to sue me then to get those attorney fees, which they can't do because they have no grounds.
And so where does this case sit now?
Well, of course, it was dismissed, and then the judge ignored the fact that I have 4, not 3 kids, even though he cited 3 of the 4, just leaving out the important one for purposes of this situation. Once I found that Attorney General lie document that they had published and then hid away, I found that, like, after I had filed and after it was dismissed, and I had filed with the 8th Circuit, and then I filed an emergency petition with the 8th Circuit saying, hey, I just found this. This proves that they lied, right? Well, then the 8th Circuit, of course, affirmed the lower court without addressing the massive substance of, and if you look at my YouTube, you can see my appeal. It's like 40 pages. It's nothing I do is short these days, because I need to get every single word in there, and they can cry if they want, oh, that's too many words. Okay, well, actually, the 8th Circuit said that to me. They said, nah, this is too many words. I said, cool. Then what I'm going to do instead, and I actually put this in a brief and sent it to him. And I said, what I'm going to do instead is I'm going to hyperlink sections. And since I don't really have to then worry about length at all, because I'll shorten it a bunch and just send people to these different things to read everything, I said, I'm going to go all in, and I'm going to expand this thing so much. And they're like, we'll take it. We'll just it's fine. Just leave it as it is. Because of course they then again dismissed without, or they just affirmed without it, with just, we affirm. And then I requested in bank, we affirm, right? So then I filed a Freedom of Information request lawsuit, because I've been diligently filing the Freedom of Information requests against the AG, the school district, now the UPL. And I explained to them, and I don't know if they get it yet, but they're going to, that you guys will never give me what I'm asking for. And I explained this in court to the judge. I said, you'll never give me what I'm asking for, so I'll just keep requesting these FOIAs, which means every single time I have a new cause of action that gives me years to file. Every single time. Because you're not going to give me what I'm asking for, I wouldn't have to file the suit. So if I ask something and you don't want to give it to me, I'm going to file another suit. So what they start to see now is this fact that I have this method of, I can sue them over. Now, obviously, their main goal is to exhaust your resources, your time, the time limits. I mean, if that's the other thing that people should understand. Like, the amount of time alone that it
Yeah.
takes to do this,
Yeah.
and then notwithstanding how many thousands and thousands of dollars in filing fees and papers and serving people and driving to Lincoln and driving, I mean, it's
Postage and
it,
organization and
everything, subscriptions to my AI,
Yep.
countless costs that, and they know it because who's the only person paying? You are.
Right.
The state's
all
not
paid to
paying,
be
the
there.
school.
Yeah.
The district's not, nobody else is getting it in their own pocketbook. It's coming from the state or the government or the organization or whomever. And so their goal is to bleed you dry while making you look crazy, so that at the end of the day, they've done nothing wrong. You're the crazy one in it, and they've tarnished your name. Like, if you look my name up now, it looks like I'm a huge problem. You type in Justin Riddle Omaha, all you see is cases. But the reality is a bank lied, the school district lied, the AG lied. Like, these things are so simple.
And the lawyers see a profit center. So let's just drag it on as long as we can.
Well, I found out, and I brought this up in this board meeting a month or two ago, that they now have a new line item that's the first time I've ever seen it in the school district's budget, that just popped out here in July. $349,000 for outside counsel. They already pay the same place as they have them on retainer. They pay them like $1 million a year. So now they're adding, because I am pounding them so hard. So the attorneys, of course, love it, like you said.
Right.
But the thing is these attorneys are lying, and they're putting it in writing, and they're so confident that they're insulated that they can just get away with it. But I've actually cut off all of those avenues. So we should have an update on that sometime.
Yeah. Well, we'll definitely have to have you back on that. That this is a fascinating, interesting case, and it's certainly something that to think about. That if we just start filing FOIA requests in all these cities, whether we want the FOIA requests or not, it's just going to tack up their lawyer bills, and we might make the lawyers rich, but at some point, it may start to affect their time budgets and everything else. And so that's what we're going to look to do with our new website, and municipalterrorism.com, by the way. That's what we are.
And importantly, if you file a complaint against the business, if it's like me, it seems to always be the government that's,
right.
But like, if you file a complaint against, like me originally, against the bank, and then you file the complaint with the Attorney General or the Department of Banking, and then they do an investigation, you can FOIA that. So it definitely helps you. It's like, that's your info right there, because they're saying, here's what we have. Well, this doesn't prove anything, guys. You can't make your decision based on something that's not there.
Right.
So the FOIA route gives you a quick route, but you have to file a complaint first with some state department so that they have something that they have to report back.
Right. Makes sense. Fascinating stuff, Justin. Fascinating stuff. And I know we have a lot more to cover, so we're going to have you back. But
that'd be great. I appreciate it.
If you make sure you send me we'll talk about that in a second. But I just want to thank you for giving us your time and telling us your story. And we're excited to celebrate in your And like I was saying, we're excited to celebrate in your victory, and we applaud you for your dedication and perseverance. And it was just a miraculous thing to watch that oral arguments and hear your story. And thank you for giving us your time. And I'm gonna give you the last word.
I appreciate it. I think you're doing a great thing, and I think everybody that's watching probably needs what you're bringing to the table, because we're all in this together. And that in mind, I think something that everybody should consider at points is like, we want to make calls to places for each other. We want to call the states and the courts and things for each other, because they get 30, 40, 50 calls from people across the country saying, my eyes are on this situation.
Mm-hmm.
You suddenly get a little bit back in terms of they're going to think just a little bit more before they try to railroad you. But don't kid yourself, they're going to try to railroad you. So just stay strong and work as a team if you can. Find people to rely on. And I really appreciate everybody watching, honestly. I mean, it was kind of fun in front of the Supreme Court, honestly. I really thought they were great, and they did a great job, and I enjoyed it. And I'm glad that everybody had a chance to see something, and hopefully it gives you guys some hope.
Absolutely. Thank you again, Justin. Thank you.
Likewise. Take care.